This Week in Law starts now with Ayaz Akhtar, Sean Flame, Evan Brown, and me, Denise Howell. We've got the Innovation Act that passed the House. A-Prime drones will discuss the legal barriers to their use. 23andMe, Google Glass, Goldiblox, and the Lost Mashup, and much more next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown. Episode 238, recorded December 6, 2013. Gourmet Cheese by Drone. This episode of This Week in Law is brought to you by Tonks Coffee. Tonks offers bi-weekly subscriptions. Tonks sources their beans directly from the growers. They're roasted and shipped within 24 hours, giving you the freshest coffee beans in the world. For a free sample, visit tonks.org/twit. That's tonks.org/twit. Hi, folks. It's Denise Howell here, and you're joining us for Twill, This Week in Law. My co-host, Evan Brown, will be with us shortly, so don't miss him too much. Hopefully, he'll be on before you know it. But we're going to go ahead and start the show today without him, sadly, for a little while. We do have a great guest with us with a great name, Sean Flame. Sean is a lawyer in Maryland and has done some research about antitrust law and the copyright alert system, and is currently with the Social Security Administration. Is that right, Sean?
Yes, that is, Denise. Thanks for having me on the show, too.
Oh, it's great to have you on. Definitely excited to talk about lots of stuff that's been going on this week. And we're thrilled to have with us Ayaz Akhtar from TNT and Know How. Hi, Ayaz.
Hi, Denise. It's great to be here. And every time, I'm going to say this up front, I'm ill-prepared, but I hope to bring at least some knowledge and probably more entertainment than anything.
Perfect. Some knowledge and more entertainment is all that we ever ask from our guests. So speaking of things that involve both knowledge and entertainment, let's talk about Jeff Bezos and his appearance on 60 Minutes last week. My dad called me up the following morning. I didn't actually see him on CBS the night before, but all excited, as was the rest of the world who saw his interview, not just about everything Amazon has been doing, but what they might do in the future, including buzzing little delivery drones around to drop off our packages, the Drone Prime service, which, of course, is still very much on the drawing board and was not targeted for any kind of reality-based release until 2015. That's not just a question of needing to develop and fine-tune the technology, but also because of the regulations in place that the FAA is not even scheduled to address until September of 2015. So I wanted to bring up the Amazon drones project on Twill because of the legal angles to it, and also just because it's fun to think of drones buzzing around and doing things other than monitoring our every move. So let's start with that. Ayaz, I know you guys have discussed this on TNT. What's been your take there, and what is it on the legal front?
Yeah, the take on TNT was pretty much, it looks like there's a lot of brilliant PR going on for Amazon around the holiday season. So it's like, let's show up on 60 Minutes, and it's going to have everybody talking about Amazon, as if you would ever forget that Amazon exists. But on the legal aspect, it seems like the first thing I started thinking about was the amount of liability involved, because when you see something flying near your house or coming towards your apartment or any of that stuff, the first thing I keep thinking of is it's going to hit something, or a person, or it's going to hit a power line. That's going to cause a whole lot of issues. It actually seems like an excellent final exam question. Amazon drone is shipping a gift from a friend, so you didn't actually order it. It goes into a power line drops, electrocutes a couple people who are standing in a puddle, because that's what they always do in those exams. So I was just thinking, how on earth is Amazon going to insure themselves when it comes to this? Because you know that when it comes to drivers and when it comes to package delivery people, they're insured, and they have to make sure that everything's taken care of there. So on the legal front, and then there's the whole FAA stuff, that's a whole other domain. But the liability aspect just seems really high.
Yeah, it's like they want to take, in law school when we take torts, which is the class that is all about
Desserts.
maiming and destruction. And the case that everyone studies is called Paul's graph. So it's like Paul's graph for definitely the new world. Sean, what do you think about these drones? Are you welcoming their imminent arrival in 2015, or do you think that this is, as Ayaz and the TNT folks speculate, just a way to get on the radar during the holiday season?
Yeah, I mean, I actually really do think it's I'm not going to say a publicity stunt, but obviously it is definitely a way that Amazon is trying to get some attention during the season. And I kind of agree with you that not only, the legal perspective of this, but I think technologically, these drones aren't really at that state either. I mean, I remember one of the things that we're talking about is, well, if you're within 10 miles of the plant, that's the delivery area for these things. Well, are they going to have a warehouse every 10 miles? I mean, it's with the range on these things. I mean, I can't see the use of them as being very, very heavy. So.
Great. Hey, just to let Patrick know in the studio, Evan is there and ready to rock whenever you're ready to add him. So we'll go ahead and get him on the show.
Here. I am here.
Oh, you're actually here. Hello, Evan.
Yes. How are you? Good to see you. Yeah. Sorry for the late arrival here. The best part of the show is sometimes the pre-show banter. So, glad I can drop it.
Evan Brown brought in by drone today by Amazon. Amazon Prime Air.
Capturing in.
Thank you.
He's within the 10 miles.
Weighing in a svelte 5 pounds, because apparently that's all that they're going to ship around with those drones is little packages, which they say, and this surprised me in reading some of the coverage, that most of their deliveries involve packages that are 5 pounds or less. I can tell you right now, I'm a heavy Amazon delivery customer, and hardly any of our packages are 5 pounds or less. Yeah. So I guess we would be underserved by the drones. We're in the Prime Fresh market test area for Southern California. So they've got these green trucks driving around everywhere. They've got their own trucks now that deliver groceries. And it's interesting. Prime Fresh is sort of cannibalizing their Subscribe and Save, which is, again, this is why none of our packages are less than 5 pounds, because when you do Subscribe and Save, you buy in bulk and you get a discount. Amazon Fresh seems to be the opposite of discounted deliveries. It's all about convenience and high-end gourmet items from local vendors in the area, as well as a lot of existing Amazon stock. So you want to get, the gourmet cheese delivered to your house, but you're also out of napkins. It will cover you both ways. So I am all for Amazon figuring out ways to make life more convenient. I just don't want them chopping off people's heads with their little copters. Evan, what do you think about this story?
Well, you can just put little guards on them, right? That'll keep, OSHA's got to be involved somehow in this. That'll solve all the problems here. So, well, yeah. Where do we start on this on this issue? I mean, first of all, I'm not necessarily a Jeff Bezos fanboy or what have you, but I don't like seeing people make fun of him for being forward thinking like this. Sure, technologically it's not there yet. Yes, of course, legally it's not there yet. But what's the difference really? This is just a difference in magnitude, not a different in kind, than any kind of futurist looking to what the future distribution models and services are going to be. So I think it's tremendously exciting. I think it's great to see that there actually is somebody who has the means to do this. I've seen in commentary, who else on the face of the planet, but Amazon would be able to pull something like this off. It's great to see it, because without actually taking steps toward it, when are we going to have the opportunity to address all the legal issues that would arise from this, all the way down from the FAA to local, the municipality regulation of stuff, to the interesting tort liability questions, to the insurance questions, to the UCC Article 2 sales of goods questions, like what happens if the drone crashes and the $5,000 Rolex you ordered, is destroyed. All these interesting types of things that are there, plus the economic aspects of it at all. I could see that the carriers like UPS and DHL and FedEx could be pretty. Is DHL still around? Could be concerned about this, because that last mile of delivery, logistically, tactically, is a challenge. But that's where most of the the efforts of those delivery services really comes into play. So are there going to be UPS drivers who are out of work because of this? So I think this is a fascinating issue, and I'm really glad to see it's here. And I get sad to see the detractors talking about it.
One of the crazier things that popped up, at least online, was the idea that people would be able to steal things easier by shooting these things out of the air. And I'm like, where the heck are you getting? Like, there were posts about this idea that you're like, okay, I'm tracking this, and I got my shotgun out or whatever. You can have a rifle, I guess, so you can shoot this.
Like a big electromagnet.
Oh, could you imagine spoofing
awesome.
GPS coordinates so it can actually find you by accident? I guess that would be the new level of it, just how far up in the air this thing's going to go. It's going to cause a whole new world when it comes to that. But like, as silly as it sounds, I enjoy like living in the future. Like we have like tablets and we have cell phones and everything's connected. Now we're going to have robots bringing us like maybe an apple because it's under 5 pounds. But like that's crazy. So I'm excited about it. But the legal side, it's just like, I don't know how they're going to figure this out. But then again, we have motor cars driving around, so that seems a little crazy too. Here's a little piece of metal that holds giant explosions all the time, and we're going to drive these around, and they can kill people, but that's okay. We'll figure this out, and we'll put the horses aside. This stuff is going to take a long time to figure out.
There are opportunities. There are opportunities for death at every moment. When you stand outside your door. There. And, so why on earth are we afraid about these, why are we afraid of these little things that, have, blades that could severely lacerate you and maybe die if it come with enough velocity right toward your head or something like that. So, I mean, this seems like relatively minor. We're perfectly accustomed to, the organisms flying around in the air like a Canada goose. For some reason, I equate, the size and the mobility and the nimbleness of one of these things to that. We don't freak out if we see a Canada goose fly over.
I do.
So, as you have your own issues. But
this is true. Long story.
50 years from now, they'll be looking back on us having this conversation saying, oh, look how naive they were back when it was almost 2014.
Right. And Canada geese have their own hazard issues involved with airplanes and things as well.
Yes.
What were you going to say, Sean?
Oh, no, I was just going to say, I'm kind of imagine that people were sitting around back in 1910 when cars were invented, having these kind of same conversations. So,
right.
I mean, this is not something unusual. And I mean, I think this is prototypical Jeff Bezos. I mean, I think this is what makes him such a great entrepreneur is just to throw as many things as possible against the wall to push the ball forward. So,
right. Well, I promised we'd discuss the legal angle. We talked about the Paul's graph for what sort of harm is foreseeable and who should be responsible issues when you've got these things running around. The two legal stumbling blocks that they face right now are drones are not legal for commercial use in the United States at all. And they're not, I'm not quite sure. I don't think that they are legal for autonomous flight under any circumstances. I think, the little RC drones, the AR drones you see flying around are okay because they're direct line of sight to someone controlling them. So those are the two hurdles that the FAA will have to grapple with and do something about before this will be legally possible in the United States. And again, I mean, you could see, as Sean was saying, you could see back in the early half of the last century, people sitting around having the same kinds of discussions that we don't want these on the roads. They smell bad. They're dangerous. But they've found ways to get over it. And, the FAA, though it moves somewhat glacially sometimes, does have a way of grappling with these things and changing when appropriate. We just saw them change the rules about using electronic devices on planes. So who knows what will happen in 2 years. I do think that, and here's my segue to the next story, I do think that there's an interesting tie-in with the tax issues that Amazon has been facing in the various states due to their affiliate programs and what amount, the whole question of jurisdiction in the modern day becomes very interesting too. What amounts to sufficient nexus with a place to get sued and have to pay taxes there. And what we had in New York is a case decided there that, yes, Amazon would be liable for sales taxes because of the fact that it pays its affiliates there in New York, and the U.S. Supreme Court just passed on taking that case and reviewing it, so it will stand, and Amazon and other online retailers will be bound by it. Sean, how do you think this changes when Amazon's not only paying affiliates in a state, but also, of course, doing all kinds of business with the residents of the state, and physical deliveries not only involve hiring a third-party carrier, but more increasingly, and with this plan in mind, specifically involve Amazon doing it itself?
I mean, I think here we're running into kind of the old rules that exist on how you establish jurisdiction. I mean, going back to these personal jurisdiction cases, the Erie Doctrine, and all these different things. And I think there's just a more modern recognition at this point that jurisdictional rules are changing. I mean, it used to be that almost all of the economy was based on kind of a local purchasing and local sales type of thing. And that's just not the way the world works anymore. And I think that actually the Supreme Court's choice in not taking this case is it wants to let this issue percolate a little bit more, because I think it might be on their minds that some of these older cases might be getting close to reaching their term limit, their age. They might be getting close to being overturned. My own view on this is actually something much more that should be in Congress's court. But, of Congress right now, you don't know what's going to happen. So,
Evan, any thoughts on the different sales tax cases? Obviously, different things are going on in the different states, but this is the first sort of consideration, even if it's a non-consideration, from the Supreme Court on the issue.
Well, right. I mean, I see it perhaps different conceptually from, just pure internet jurisdiction, because there actually is a case pending right now where they had oral arguments about, well, it wasn't a pure internet jurisdiction case, but it had implications about what you do in one state affecting results in the other states, the Calder versus Jones analysis, which really seems to, form the touchstone for most of the cases that deal with personal jurisdiction over the internet. But conceptually, if we rise up to a higher level, we can draw a circle around these issues and generalize about them when it comes to the Amazon tax issue, because what technology affords us to do here is have a presence in many different places. And what the drones would do, I think that you were making at least one attempt to tie the drones issue into this as well. I mean, what that does in a very physical and real way, if Amazon were to launch something like this, is distance itself from the ability to say, hey, we are just out here in Washington doing our thing, and everybody else is doing it, buying this stuff where they are. We don't have necessarily a physical presence there. It does something to undercut its actual fundamental argument of a lack of a nexus to where it is. And that, you'll see, is just an extension of the same problem we've had since the first internet jurisdiction cases started coming out in the 90s. If you think about the Zippo case, the interactive sliding scale, or the sliding scale of the interactivity of a website, which, even though it was a district court opinion in 1997, still forms a big basis of our jurisprudence when it comes to how one whether one should be subject to personal jurisdiction because of their activity over the internet. And so there's, of course, no surprise. This is belaboring the obvious, the understatement of the day, to say that, as technology gives us the greater ability to communicate and actually do business, and to the extent send drones out there, there's this tighter physical nexus, which should weaken the argument that you're remote from that location. So the answer may be, you do allow an exercise of jurisdiction, personal jurisdiction, over companies that may have their corporate headquarters farther away. But at the same time, maybe we should make the whole process of litigation different, where it's easier to litigate a case in a foreign jurisdiction. You don't have to, shouldn't have to show up there quite as much. More hearings should be done. Evidentiary hearings, what have you, could be done without actually having to be there. There's no reason why technology can't, if technology is going to make a entity more subject to jurisdiction somewhere else, there's no reason why technology also couldn't mitigate the hassle that comes from that as well. So,
but where does it stop, though, right? Like, if you're talking about corporations being called in from a state, what makes me different than that? if I have a Facebook page or if I'm targeting a certain thing, where's the line there? I think that you can have this by court case, but to have legislation might be a smarter idea so we can actually define the limitations. Because while I do think Amazon might have the minimum contacts test, international SKU, that kind of stuff, maybe they do have they are supposed to be held to collect sales tax. The thing is, I'm curious about where does the line end when it comes to just actual people? Because the internet's made everything and everybody accessible pretty much anywhere. What happens to me if, like, I say something stupid about New York, even though I'm not there anymore?
Probably don't have to throw away the fundamental analysis. I don't see anything wrong with the Calder effects test, and this is getting first year civil procedure kind of wonky on it. But why do we have to change the fundamental rules that we apply of somebody should be subject to jurisdiction somewhere else if what they're doing in one place is purposefully directed somewhere else and it had an effect that was felt there? You got to remember the facts of the Calder case, where the Inquirer magazine published a defamatory article from Florida about someone in California, and it knew was in California. So certainly it was directed toward California and the effects were felt there. I don't see any fundamental reason why technology should change, the rules that apply, but it may affect the way that those, what am I getting ready to say? I don't see why technology should change what the rules say, but it may change as to how they are applied, given the particular things. It could be that it's very well easier to make the effects of your actions felt somewhere else, and that's an unavoidable reality, but it still comports with what is it the standard notions of fair play and substantial justice.
I haven't heard the word comport in a long time.
I think that, by the way, I think that our goal for the show, since we've now gotten Paulsgraf and Calder into the discussion, is that we try and hit on the seminal cases from every first-year law school class.
That's all I remember. So international SKU to the end.
Right.
For all the law students who are watching, we're helping with their finals, because we also mentioned the Erie Doctrine. Didn't you say something about that, Sean?
Yes. Yep.
Yes.
Nice.
There we go. That's right. Well, what did Franklin tweet at us, Evan, that thanks to us, he was all ready for his mass media law class on Section 230 of the Communications Decency Act. So go, Franklin, ace your test.
Yes.
Where was I going with this? Oh, so, substantial notions of fairness and all. I think that, as it becomes easier to reach out and have an effect in a faraway place, it also becomes, as you were saying, Evan, easier to appear there virtually. And there would have to be some kind of balance if you're going to be able to be made to litigate in a far off place. You have to be able to do it in a convenient and cost and time effective way too. So I don't know that we're quite there yet.
We do see a trend toward that. There's more, you can appear by telephone, especially with depositions and discovery and things like that. Mm-hmm. You actually do see that in litigation, making it easier.
Right.
But anyway.
And Evan, were you on the show? I think it might have been one that you had a different thing going on that day, but maybe I'm wrong, where we talked about the Copyright Small Claims Court and how you were there for that. So you
I was there, but I had a different thing going on in my head anyway. That's not it's not unusual.
Right. That one of the things mentioned there is that if they do set up this Copyright Small Claims Court, they're envisioning a sort of virtual telepresence kind of way of appearing in the court. So, I think that's definitely on people's radars. Sean, anything further before we move off sales tax and on to other things?
No, but I'm kind of excited to see when the first court case that's going to be conducted over Skype will be.
Yeah, it's not a perfect system. I'm getting the video on this show at about, I'd say a rate of 10 or 20 second delay.
You plead low bandwidth?
4 or 5 frames a minute.
You plead low bandwidth so you can't appear. Like, that's going to be a reason why. It's like, sorry, I'm decel. I can't do this.
Right. Your jury duty excuse just included have no high-speed internet. Let's talk about 23andMe. We were Yo Quiero Taco Drone. Here's a taco suit for you, perhaps a class action anyway. over the fact that 23andMe has been slapped on the wrist by the FDA and made to curtail its marketing. Now there is a class action suit pending in my neck of the woods, the Southern District of California, being brought by a San Diego law firm. Something about San Diego law firms, they seem to like to bring big consumer class action suits. Maybe I'm just saying that because the Larac firm was based there. But that's where this one is venued, and it involves over allegedly $5 million in damages over people who used 23andMe's services, but now they're claiming there was false advertising involved because they could not meet the kinds of claims that were included in their marketing. Evan, what do you think of this one?
Well, I mean, isn't it almost inevitable that they're going to face litigation over like this because they're trying to do something interesting and innovative and provide a kind of service that's never been done before. And you know, I haven't looked at what the advertising that this was based over, so I'm not prepared to comment on that. Just here's that little, you might as well just have a soundbite for me kind of lambasting the lack of merit that I see in many class action lawsuits like this as being opportunistic for plaintiffs' lawyers. It's a little mantra, comes naturally for me every time we talk about this thing. So, you know, there's a lot of hyperbole in litigation like this, an allegation that the tests are not supported by any scientific evidence. I think, is that what the FDA was saying or what the plaintiffs was saying here? So, there's just no surprise that there's litigation over this, and an advertiser of services like this ought to be careful that they're not saying things that aren't supported. But other than that, this is one of those cases that'll settle. There'll be some modifications. The science will continue to improve and get more accurate, and certainly not going to stop the folks who I equate this with Google. I know technically it's not Google doing this, but when I think of 23andMe, I just think of Google doing this. It's not going to stop them from continuing to pursue this as a industry niche.
Yeah, I hope not. I mean, we've had a couple of stories already today where we've been concerned about innovation being squelched by either regulatory or litigatory concerns. And, this is one. You want to see a company like 23andMe be able to continue to do its science and be able to continue to provide people with information that, certainly is interesting to them. Maybe there's a component of disclosure that has to be done and caveats that need to be put in place, as opposed to, getting into marketing language that leads you to believe that things are possible with the information you're going to get that really aren't. But certainly access to that kind of information is something that we want to encourage. Don't you agree, IAS?
Yeah, I think the information would be great to have. But I think the deal with the FDA and 23andMe has been like an ongoing issue. Looking at that warning letter from the FDA, they're saying back in 2012, we were trying to get you to comply with us, and you guys weren't. So this has been going on for over a year. So it's not just like the FDA just finding out, they did a Google search finding out, the saliva testing thing, this guy just showed up. It looks like they've had an ongoing relationship, and the FDA's been trying to get them to comply, and they haven't. So while the information is something that people want, I mean, there is definitely an interest by the FDA to say, hey, listen, we don't want people taking preventative surgeries or preventative measures that might make them more ill. That seems more about educating the consumer, and that might just be something to be written in the results or the information that 23andMe gives you. If it just says on the top, before doing anything, consult a physician. I mean, we see that warning for every exercise program that ever existed. If it's something as simple as that, and 23andMe for some reason can't actually comply with that seems a little odd. So whatever their ongoing dispute is, they have to resolve it, and it's going to have a disclaimer at some point.
You're dreaming if you think it'll really be that simple. I mean, one of the most absurd things about the modern world is advertisements on TV about pharmaceuticals. I mean, if you ever watch an ad, there's about 4.3 seconds of a baby boomer aged couple. The guy's concerned about his cholesterol. You see them doing something wonderfully demonstrative of the successes they've enjoyed in life and the happy ideal marriage and everything and all that stuff. You capture that for about four and a half seconds, and then you have about a minute and a half of all the side effects that include death and disembowelment and all that stuff. And so, that's how it would turn out if you get the FDA to involve.
Well, yeah, but we're talking about, so you get your results, right? Just imagine that piece of paper you get when you sign away your life for your wireless contract. Like, nobody reads that thing. It'll just come along with it. And that weird thing is that will make people happy, at least in the government aspect of, yeah, you had disclosure. But like for the actual public, are they going to read it? Probably not. Are they going to act stupid anyway? Yeah, because that's what people do. I mean, that's why we have a lot of these things, because you have this warning, like, don't use your hairdryer when you're in the bath. Like, they had to put that on the actual device. So if they can't put a sticker on this, even though I'm not saying that people are going to read it, I'm just saying this will probably make everyone happy to have a little tag on it. So before you open this, you must read this sticker. Nobody does that.
I hear you.
Right.
Because I'm dreaming.
I used to love, I forget, I had it as like a screensaver or something. It was a picture of some packaging for a child's costume, and there actually was a label on it that said, "Warning, cape does not enable user to fly." Something you need to bear in mind. Sean, any thoughts on 23andMe?
No, I mean, I see this lawsuit as basically kind of your traditional, here a big regulatory agency has taken an action, and now we are going to file a class action lawsuit, kind of piling on, kind of making the same type of allegations. And I mean, I think it goes back to exactly what Ayaz was saying. Like, this is really, the lawsuit is kind of secondary. I think it is going to end up in a small settlement or something else. I mean, the real issue is whether or not 23andMe can hit upon the right information that they can give to their customers in such a way that they can get past this paternalistic medical system that we have. Because it's, this isn't really even just the FDA. This is medicine in general is extremely paternalistic. You can't go to the drugstore and buy your own drugs. You can't, for the most part, get your own blood tests or things like that. You can't you can't go to ask for an MRI without a doctor's prescription. They want to have some sort of professional intermediary to explain these things to you, because they fear that for the most people in the country, when they get this information, it's going to either lead to bad choices one way or the other. So.
All right, another instance of technology colliding with law, and law perhaps not being up to speed enough on what should really be regulated and the way it should be regulated, is the woman in San Diego who was wearing Google Glass and got pulled over. Cecilia Abedi is her name, if I'm saying that correctly. Was wearing Google Glass in the car and got pulled over. And the particular California law that she was cited for has to do with using video devices while driving. And they're fighting this. She has a lawyer, William Considine, and they're going to take this to trial if they have to. So, Evan, we hoped that she would stick this out, and it seems like she is.
Yeah, well, that's fine. I stand by what I said when we talked about this earlier. I don't think it should be lawful to use one of these devices when you're driving because of, the public safety issue that presents. So what it looks like it's boiling down to is a factual issue that's going to depend on some parsing of the statute and, some evidentiary issues of whether she can prove that it wasn't on when she was driving. But, that doesn't do anything to deal with this larger public safety issue, and it's one of those things that we're going to have some clarification on, in the law. But even more importantly, clarification, something built into the technology, and I'm saying that in a very general sense, not like some particular widget built into something, but some manner that the technology can be used so that there is a very clear line as to whether it's presenting this public safety risk. So. Right. This is interesting. We'll see, it'll be interesting to see how this goes out, but this is by no means going to be a watershed event for the future use of this technology. This particular litigation is not going to be a watershed event for whether or not people are yes or no will be able to drive with Google Glass and comparable technologies that are developed in the future.
Yeah, it's really going to require an assessment and acceptance of newer technologies by state legislatures and them giving guidelines to drivers as to what's okay and not okay. In the meantime, what we've got is just one of those other opportunities for death once you step outside your front doorstep, Evan, that you mentioned before. Is the driver who goes by on the street going to be wearing glass or not? Sean, were you going to chime in?
No, I mean, the only thing I agree with Evan for the most part, but we do allow people to drive with GPS units. So, and yeah, I've never actually seen the screens on Google Glass, but my understanding is this isn't kind of a full motion video type of device. It's more of these little note cards like they've added to their iPhone, the Google iPhone app. And so it's really how much distraction is it? And that's not something that's going to be resolved in this criminal trial. That's something that, no matter which way the criminal trial is going to go, the legislature is actually going to be the ones that are going to really, figure out what the rules are on this one.
Yeah, but we already have reckless driving laws, right? So this idea that we're going to start singling out pieces of technology. I know that there are rules about cell phones and usage of hands-free cell phones and GPS, when is it supposed to be on a video screen or this or that and the other thing. But the thing is, in the consumer electronics space, one of the biggest push has been wearables. So, we've seen all these smartwatches. They might not be that great, but we're going to see a lot more displays on a lot more surfaces. So if you're talking about, on your glasses or on your wrist, I mean, my watch right now is just a regular analog watch. But like, if it has more data, is that going to get me pulled over? Now, this person was actually pulled over for speeding. And so when she looked up at the officer, it turned on glass. At least that's her argument, which makes sense. But the thing is, if you're going to be a responsible driver at all, that's something, that's a responsibility. You're licensed to drive. It's a privilege. So when it comes to that, we already have laws in place for that. So the case, you guys are right. The case probably won't mean a lot of things other than it's just fun because it's Google Glass. It's brand new. But someone's going to figure out that this technology will kill people, and we have to have specific rules about it and extra, we'll have another citation for it. But it's just something that reality has to deal with. The law has to deal with the reality that we're going to have a lot of machines on us at some point. And how are we going to handle that? It's basically being responsible behind the wheel. That's the real key at the end of the day.
Well, and this is becoming a more and more real issue. Obviously, Google Glass will be available at some point in the near future. And just this week, they had the announcement that Vuzix Android-powered M100 smart glasses are available for pre-order by consumers. They're going to launch early next year, and they're available for about $1,000. So did you guys do that one on TNT?
No, we covered it when it was first announced a while ago, but it's actually come to market now. I think it's $1,000. Not Vuzix they've always had like my favorite technology of these wearable screens. You just put them over your eyes. I always thought of them as the ultimate thing for airplane travel. Or you just like, okay, I don't want to talk to anybody on this plane. I'm putting these glasses on. But these are, they've been around for wearable for a long time. They just don't get the same buzz as Google does.
Mm-hmm. Maybe that's a good thing if you're driving.
Possibly.
All right. So let us take a quick break here before we move on to our other stories. We're here today discussing issues at the cutting edge of innovation and technology and law with Sean Flame, an attorney from Maryland, Ayaz Akhtar, another host here at Twitch from TNT and Know How, Evan Brown, an attorney in Chicago, and me, I'm a lawyer in Newport Beach, California. And we're gearing up for the holidays. I'm sure you are too. And it's been really great for me in the last couple of years that the Twit network has helped me out a lot during the holidays. Last year, as I remember, I was up visiting at some point in the fall and encountered the lovely Biscoff spread that you guys had in the kitchen. And I wound up sending out crates of that stuff for Christmas because it was so good. I'd never had it before. And a lot of friends and family thought it was great too. Now this year, Tonks Coffee is high on my holiday list because Tonks Coffee, everyone loves coffee, right? Really good coffee. Tonks Twitter feed, if you check it out, you want to see how good this coffee is. You're going to see how extraordinary it is when you read the comments over there. And so, you during the holidays want to do something that's really special. It's nice to do something that's warm and something that will keep coming back and be a gift that keeps on giving to the recipients. And that's what Tonks is. It's shipped within 24 hours of roasting. Homebrewed coffee can be just as good as your favorite cafe. It's not as hard as baristas make it out to be, but it all starts with fresh beans, which you can't get if you buy bags of beans from grocery stores. Pre-ground coffee is even worse. Great coffee actually has very little to do with fancy gadgets and expensive gizmos and everything to do with the coffee. So that's where Tonks comes in. It's a bi-weekly subscription which sends the very best beans on earth directly to your door for the price of a few cafe visits. If you're hitting a cafe most mornings, and goodness knows I do most mornings, this is a much better and more economical way to get great coffee. I'm afraid I don't think they're going to be dropping them on your doorstep with drones. Not just yet. But still, that shouldn't dissuade you. It sources directly from the growers. Because of their extensive relationships, Tonks can follow the tilt of the earth and select the very best beans when they are at their peak. This makes a fantastic holiday gift, obviously. If you're looking for someone that's hard to buy for, why not get them a great cup of coffee every morning? So much more meaningful than a gift card. Tonks cares about the experience of its customers and is available to help with any brewing questions and ready to offer tips and advice. So if you fancy yourself a coffee connoisseur or just love coffee, you need to try Tonks Coffee. These guys are fanatical about delivering the best beans in the world. They source directly from the growers. They roast it. They ship it within 24 hours, so it's fresh as it can be. Every 2 weeks, you can get a new batch of incredible beans or send a new batch of incredible beans to your friends and family, roasted to perfection. Tonks is subscription only, and they're offering a free sample to our listeners. So check it out. Visit tonks.org/twit to get some for yourself, or send it to someone you know who appreciates the finer things in life. Visit tonks.org/twit today. Thank you so much, Tonks Coffee, for your support of This Week in Law. All right, let's move on to some stories on the copyright front. Sean, one of the things that you've been heavy into researching, it's particularly last year before its launch, are the antitrust implications of the copyright alert system, which I'm really fascinated by because in all of the discussion that we've had about the copyright alert system and its pros and cons and whether it's a good idea from a policy standpoint, I really hadn't thought about antitrust before. So why don't you tell us how that comes into play here?
Well, sure. I mean, the copyright alert system is obviously a group of private companies. You have the content industry, and you have a large number of internet service providers coming together and privately and doing something. And anytime you have businesses that are normally competitors with each other that come together and kind of cooperate with each other, you have to think about antitrust law. And antitrust law, in essence, is trying to regulate business behavior so that companies don't come together and say, okay, we're going to set the price a little higher in this market, and we're all going to walk away with a little bit more money. And so it was actually kind of interesting. When they first announced this system, I was actually still in law school, and I had just finished a course in antitrust. I was sitting around in the summer at my internship, and this story came across, and it was just kind of that trigger of seeing. First I had kind of been paying attention. I was already into intellectual property law, but here I saw something that really tied antitrust and intellectual property together, and so that is what kind of made me start thinking about, well, this is something I want to write about. I want to see, is this a kosher type of a deal or not? And so I spent basically the summer planning it, and I ended up writing about it for an advanced course that I had my last semester of law school. So, I mean, that's what kind of got me interested in it.
Right. And so it's a bunch of private companies. What they're doing is sending out notices based on people's activities being monitored by their ISPs. Tell us specifically why we should be concerned that there is an anti-competitive aspect to that activity. Sure.
If you go back in the history of antitrust law, back in, I think it was the 1940s, there was an organization kind of like what would be the MPAA. It was called the Fashion Originators Guild, and it oversaw a lot of the different large fashion houses. And, people if people aren't aware, copyright doesn't protect fashion designs. I mean, that's one of the reasons why you'll see a designer come out with something and then immediately 150 clones in all the various different stores. And so the Fashion Originators Guild was basically all the fashion houses, and they came together and they created a system where they would go to retailers and they would say, okay, retailer, you can only sell the stuff that comes from us. If you sell any of these copies or knockoffs, we're going to cut you off. We're going to stop giving you any of the clothing. And you can see, just by what I've said so far, it's very similar to what the copyright alert system is. So in the copyright alert system, you have the content industry, and they are saying they are kind of deputizing internet service providers who really don't have any skin in the game to oversee the copyright. But it's not copyright law. It's a form of copyright that they're not actually legally entitled to. If somebody violates a copyright of an MPAA movie studio, that studio has one remedy. They can go to court, and they can sue the person, and they can try to prove their case in court. The copyright alert system, they're without any form of due process, are enabling these messages to come to you, and then later, with a form of due process that the person actually has to pay for, $35, have the ability to slow down internet connections. And yeah, remember when I first wrote this story, it wasn't quite clear what the consequences were going to be. I mean, people were talking about disconnections, people were talking about slow down internet connections, and so the system itself sounded much more of a punitive. We're going to have another means, an extra legal means, to go after people. And so that's that Fashion Originators Guild that I talked about was actually a case that the Federal Trade Commission brought a lawsuit against them, and that went to the Supreme Court. And the Supreme Court said that this is an illegal restraint of trade, that this is something that antitrust law is designed to protect. You're creating new laws, and that's Congress's power, nobody else's. So, I mean, that's why you would want to kind of be worried about a company getting together to do this, because if an ISP can come up with the content industry and ISPs can come up with the rules for this thing, you imagine other things. There are other things that they could force you to do in order for you to get your own internet service that you're paying for.
Right. The copyright alert system has been in place for several months now. And one of the things that has struck me about it is just the lack of uproar, coverage, someone waving their outraged demand letter in the air and fighting back and taking it to arbitration. It seems like it's been really quiet. Do you have any thoughts on that, Sean?
I do. I mean, I actually think that the system was announced, and there was immediately an outpouring of response. I mean, not just my article, which looked at it from an antitrust perspective, but there were at least two other articles in the legal academia that kind of analyzed it from other points of view, and then the massive amount. I mean, Ars Technica was all over it. All the different technology sites were over it, and there was a lot of pushback about this system. We need to know more. I mean, we need to have some more transparency. And then, kind of something along the way, something good happened. They actually decided to bring people on. Gigi Sohn, who's now at the Federal Communications Commission, but she used to be at Public Knowledge, and two other people that the names I'm blanking on right now. But they brought these people on to kind of give a consumer point of view. And so over time, from the way it was originally described to the way the system was actually implemented, it went from being much more of a here's our private enforcement system that we're going to be able to take action against customers, which my understanding is the internet service providers weren't actually really happy about that part of the deal. And that's actually something the Obama administration pushed for. It changed much more now to an educational system. And as an educational system, I don't actually have too much of a problem with it. I mean, this is, I don't know that it's anything new, because I understood that ISPs were before they were passing along notices to customers when they got notices before. But having a regularly formatted system and being able to keep track of who are the people who are infringing the most or allegedly infringing the most, is also useful if the content owners actually want to use their real authority, which is to bring a lawsuit.
Right. So at some point, if someone decides to combat this, do you still think that they could raise antitrust as a challenge to the system as a whole?
I certainly think that that would be something. I mean, really here you have to think about who's actually going to be a plaintiff in this. You know, if it's going to be an individual person, you know, an individual person doesn't bring an antitrust complaint. Really, the only or at least not successfully, and not unless it's a class action, and not unless you have the kind of funding that that class action lawyers get. So my imagination would be that if there is, the only way that we're going to see some sort of enforcement action, at least on antitrust grounds, is if the system starts being abused. If that abuse somehow raises the attention of either the Department of Justice or the Federal Trade Commission, and it's not resolved informally before one of those agencies needs to take some further action. And honestly, given that the Obama administration was so integral to putting the system together in the first place, you know, that's going to be a long time, if ever.
Evan, do you feel like the fact that we're not hearing much controversy about the copyright alert system as it grinds along, do you take that as a sign that it's working?
Well, have we agreed on a definition of what it means for it to be working? You know, that seems
no, definitely not.
Yeah, the important threshold issue on that. So I don't know. There's a couple of different ways of looking at it, and you know, I actually use this whole shift in the content industry's approach here in collaboration with the ISPs and what, you know, this whole mode as an example in my to my students in my negotiations class about the different tactics you could take in a negotiation. If you look at this at a very macro scale, the content industry on the one hand negotiating, you know, how to coexist in the world with users of content who, you know, want to engage in piracy. And I'm saying that word without trying to freight it with any negative connotation. Hotfile, motion in limine order aside. You know, so there's this idea of, you know, in the first few years of it, 5 years or so, from 2003 to 2008, if you remember the aggressive litigation that the RIAA undertook against its individual users, the consumers of content here, you know, that tapered off beginning in 2008. And now there's this other educational component to it, which is part and parcel to this. So maybe it could be that if we are going to agree on a definition of it working, that you know, that education is having some kind of benefit here to make it so that people don't want to go ahead and protest this and you know, exercise rights, what have you, you know, go through this. You know, we've talked about this before, and the whole process seems like kind of a sham anyway because of just the way that it's set up. You know, what is it, a $35 fee? Am I thinking of the right things? You know, we pay a $35 fee.
Yep.
And I mean, that just seems like a nice little profit center. So maybe people see through that as well and recognize that that's even the favorable end result is going to be sort of a Pyrrhic victory. What do you really gain from it? I don't know. Maybe you get your internet service not throttled again. I don't know. I haven't really thought that through. But just my instinct is telling me, and my general sensibilities are telling me that it's just that it's not all that meaningful to even go through this process. But that, you know, there are various causes that could be coming together to affect that result.
Ayaz, are you hearing anything through your network about the copyright alert system impacting people?
You know, not necessarily. I was just thinking about what Evan's point was about the, you know, how aggressive the RIAA was or were when it came to prosecuting everybody. But what happened during that time was we had a lot more legal alternatives. You know, at this day and age, we have so many online streaming music services that it seems like access might be the best deterrent to copyright infringement. Like one of the things that keeps happening are some of these most downloaded movies in the world are movies that are still out in theaters because of all these windowing systems that have existed in Hollywood for such a long time. If access was actually granted to people in a faster way, they probably can make a lot more money. So the antitrust concept was really interesting to hear. But one of the things I'm thinking about, and just in general, is that if you give access to people and it's easy to use, like, and the DRM doesn't like destroy anything. If like this is a lot of ifs, right? If that happens, people don't really care to pirate because you don't want to go and find some site that's not reputable. You don't want to find a file, put it on your machine or put it on your tablet or phone, and who knows what it's going to do. But if there's an actual service that you're willing to pay for that Hollywood's behind, that could actually make a huge difference because it worked for the music industry, and they came kicking and screaming. Okay, Apple pretty much dragged them into that, and now they're kind of like, oh yeah, if we let people stream music, we'll make money. Duh. So maybe one day Hollywood will join the same kind of way, but this has had a lot of inertia for such a long time. It's going to be a while.
All right, well, let's make Copyright Alert System. Let's just abbreviate it to CAS, our first MCLE passphrase for this episode of This Week in Law. We've covered a lot of good, solid legal ground on this show so far. And if you're listening to the show and are a lawyer or anyone else who might be able to get professional credit for getting some good, solid legal knowledge served up to you in the form of our shows, we've got a resource over on the Twit Wiki at wiki.twit.tv with information about getting credit in your jurisdiction. Evan, you were talking about things that would make good case studies for your negotiation students. Let's move on to an entertainment-related copyright story and talk about something that might be good fodder there. All right, this came on my radar right after the Thanksgiving holiday. Goldiblox and the Lost Mashup. I've been referring to it as in my head and in our rundown. This was the company Goldiblox that makes really cool, unconventional kinds of toys for young girls, specifically targeted at girls, giving them something other than princesses to focus their attention on. And they used the Beastie Boys song Girls in their video. Maybe we can play some of that if you've missed it along the way.
Notably different melody than the Beastie Boys.
Yep.
All right. So apparently what they did was they actually pulled it out. Yeah. So originally when we had this link, it had the actual Beasties mashup in it, but now they've changed it, and that is our story. Is they got a request or an inquiry from the Beastie Boys Council, letting them know that they were concerned about the use of this song in the video, primarily because it was a commercial, and that there was a specific stipulation in the estate of the member of the Beastie Boys who passed away last year. I'm blanking on his name now. Someone
Adam
in
Yauch.
chat.
They call him Adam Yauch, but he's MCA.
So yes, that very much did not want their music used in commercials, even though, I mean, the irony of this, of course, is that the Beastie Boys were famous for taking and sampling and having sort of a, in-your-face attitude about that. And double irony that the original song here was borderline misogynistic, and maybe not even borderline, and the message of this commercial and this company and the products they sell is the opposite of that. So it was definitely a brouhaha. Goldiblox actually filed a declaratory relief action. Their initial impetus was to go into court and say, hey, we think this is fair use and we'd like a determination on that on the front end. But then they decided to go ahead and take the music out. As we just saw, they've sort of altered it down to a track that's a little bit reminiscent of Girls, but doesn't have the lyrics. And doesn't have the controversy, presumably. So, Evan, what do you think about all this?
A lot of noise, not a lot of signal here. There's two things that I think are really critical with this. One, this was a Black Friday publicity stunt. I don't think there's any way around that. They built in these litigation costs and, paying their lawyers to do some stuff here for a few hours. That was just built into the marketing budget, I bet you.
Wow.
So I think that was part of it. And the other one is this whole idea of MCA's will. I think that was a real sea change for people's public perception when it came to this, that he had said in his will, and Goldiblox, said that they didn't even know about that. So I think that was a real sea change, and when kind of the temperament to all this change, it's like, yeah, we got to respect this guy. If we're going to say that we respect them as an artist and all that stuff, that goes hand in hand with respecting what his wishes were. But that has nothing to do with the legal issues whatsoever. I think that this is just a pretty vanilla sort of fair use analysis to be done here. He looked to Supreme Court precedent like the Campbell case, the 2 Live Crew case, because I've even had mini conversation here in the IRC saying, oh, well, this was a commercial use. There's fair use doesn't even play in, right? It's like, well, it may or it may not. Just because the use was commercial doesn't mean that it couldn't be a fair use. And I think one thing that's helpful to Goldieblox, if this were to ever have been litigated, I guess it was resolved, right? If the fair use question were to ever have been litigated here, they were saying it was a parody of the actual song itself, not using the song as sort of in a satirical way, but the song was being used in itself to comment on the song. Mm-hmm. I guess I believe that. I'm not so sure. I think the primary objective of the song was to sell products, and then that the social commentary was, way secondary in second place with all that. But that's one of the things that would come in the fair use argument here. So, it's interesting. It's intriguing. It involves Silicon Valley innovation. It involves women in tech. That whole freighted issue that I can't believe I even just said that, because I can't ever say who can ever say anything right about that. And so. There's all these different issues that makes this an intriguing story, not to mention the fact it's the Beastie Boys. We all love the Beastie Boys. So plenty of stuff to get page views on stories like this.
Yeah, definitely red meat on a Black Friday. And I hadn't even considered that the whole thing might have been a stunt to gain attention for the company, Evan. So it's interesting to just sort of toss that speculation into the mix. I think that they had a very solid fair use argument had they decided to take the distance. And the video was delightful and made an excellent point in sort of turning the initial lyrics on their head and sending quite a different message. But we'll never know what would have happened on the fair use front, because they did decide to go with a more vanilla track and no direct reference to the girls' lyrics. So, Sean, were you following this over the holiday?
Yeah, I've actually, it's interesting because I've been actually doing a lot of research and writing on fair use. So, I mean, I don't want to get too far into the weeds on this, but it's interesting for me to watch the public reaction, because one of the things that just happened in the room is somebody did make the comment that, this is a commercial use, therefore it couldn't be fair use. And it's funny to think about it, because were this 1978, 1980, that would absolutely be the case. And over the years, the commercial aspect of fair use has actually been disappearing to be replaced with what they call transformativeness. And in here, the way that they took the song and created a parody of it is actually kind of the paradigm of what is a transformative use of the work. And so I was really, it was really interesting for me to see kind of the public's reaction, because this is actually a shift that's been happening basically since a case called Sony in 1980, which set out the commercial aspect, and then the 2 Live Crew case, which I can't remember the rest of the name, but that case is where transformativeness, the Supreme Court said it was important, but then it took the circuit courts another 10 to 11 years before they started saying, oh, well, that's what they meant in 2 Live Crew. And so we had a case in the Second Circuit called Carriou last year that talked about, Well, if it's transformative for who? If it's transformative because the artist intended it to be, or does the audience, is it because the audience objectively sees it as transformative? And Carreau actually said it's the audience that matters. So, the interesting thing here is, well, they were doing this, their purpose was as a publicity stunt, and they were going to, this is all commercial use, and their intent was bad. And if the Ninth Circuit were to follow Carreau, that wouldn't matter, because it only really matters what the audience thinks of the work in the end. So definitely a little far in the weeds, but I mean, this is kind of like the little declaratory judgment action that I really wish would have happened, but I can completely understand completely understand kind of everything going on. I think Goldieblox, once they pulled out the whole well, this was in his will, Goldiblox was like, okay, we're just gonna lose every bit of public support we got when we first filed this lawsuit. So
yeah. What I think is fascinating about what you just said, Sean, is the recognition, the slow evolving recognition by courts considering fair use, that there's a commercial aspect to almost everything that people do, and that can't be the touchstone for deciding if something is fair use. There's certainly a sliding scale for how commercial something is. This was fairly high on the top end of that scale of, this was an actual commercial for a product. But when you're talking about people doing things online, there's almost always some kind of commercial component, whether they're promoting some other business that they might be involved in, whether they have ads on their site. It's getting really hard to parse whether something is quote unquote commercial or not. And I think it's wise of courts not to have that factor so strongly into the analysis. Do you agree?
Sure. And I mean, I think, also, the whole commercial use aspect is really meant not so much on the part of the person who is using the person who's committing fair use, or that's not the right way of putting it, but it's really more, how much does it affect the market for the original work? Is this something that they would have that we would have reached out and pay them? And so, if you think about, like, for instance, music sampling, there is now kind of there's a market for doing sampling, and it's become more commonplace for there are large amounts of money to be paid to sample music. Here, the Beastie Boys refused to allow that sort of thing, and so you could even say that because of this refusal, they don't want to use it in advertising. They don't want to license their work to other people, which is ironic because, I mean, if you go back to Paul's Boutique, I don't know that much permission was asked for a lot of that, but this. I just completely lost my train of thought. Sorry about that.
That's okay. Let that train go into the station. It happens all the time. Any thoughts on Goldiblox and the Lost Mashup here?
Yeah, during the discussions, I was looking at the lyrics for Girls, and I think arguably there's a lot of commentary, because as the thing is playing, the first thing I heard, I'm like, oh, that's the song "Girls" by Beastie Boys, and obviously the melody is a little changed, but I was able to identify it, and I didn't even realize it was a parody at first until the song continued. But the lyrics go: "Girls to do the dishes, girls to clean up my room, girls to do the laundry, girls and in the bathroom," and it continues going that way. So obviously, like, it's mocking the very lyrics that, I mean, we were seeing this Rube Goldberg contraption, and to do the dishes, they actually have, like, some devices causing this, because these girls are engineers, so it's very different. Right. So, like, even if you wanted to say, if you wanted to argue commentary, that seems really good too. But as Sean was saying, the idea is, in this modern age, if you take a song that sounds like a recorded work at this point and you put it on a commercial, people freak out. They absolutely freak out, because it could never possibly be fair use, because fair use in the minds of people has gotten so slim, because everything's gotten so locked down, that it's kind of a scared reality to think that, yeah, you couldn't possibly have a parody. It's like, yeah, you can have a parody too, or even commentary, and that's okay. We're entitled to that.
Well, let's be careful in our. Go ahead, Denise.
I was going to say that's a sad trend if it's true, because parodies are one of the most delightful forms of entertainment in our society, and I would hate to see them chilled in that way. What were you going to say, Evan?
Well, I was going to say, we've really got to be careful in our analysis here when we're talking about parody, and because this all comes under the idea of transformative use, which that notion, that word is not in the Copyright Act, it's not in Section 107, but that in turn comes under this first of the 4 fair use factors, the nature and character of the use, including whether or not such is of a commercial nature. So when we're examining whether this is a commentary on something, we've got to be very critical in making the distinction as to whether it's a commentary on reality, e.g. the state of women in tech and the, societal stereotypes that boys like these more engineering skewed toys, whereas girls are expected to, what was the commercial they were watching? Was it a CoverGirl ad or something? Girls are supposed to do this and boys are supposed to do this. Is it a commentary on that, or is it a commentary on the work? And only to the extent that it's a commentary on the work is it more likely to be protected as a fair use. So we can talk all we want about whether it's being a commentary, but we've really got to be careful not to, conflate or, I guess, gloss over that idea of what the commentary is about, because we could spill all this ink and generate all these pixels about its commentary nature. But if it's not a commentary about the work, fair use is not going to. It's not going to have much of a fair use is not going to help it all that much, is what I'm trying to say.
I think they could have made a very good case that it was commentary about the work when you go back through the and compare the 2 sets of lyrics.
I realize that I'm getting irritating because I keep pushing on points here, and I'm supposed to just lay back and chill out, and we're supposed to move on to the next topic. But
that's okay.
I would argue against that by saying, look, the real purpose of this music, and this is something I said earlier, the real purpose of the use of this music here was not to make a commentary. That's way in second place. The real purpose was to sell these darn things. This was a commercial. It was a commercial.
Right. I think there's room for the clever commercial, I guess is what I'm saying.
But look, it's as if Goldiblox implicitly agrees that there was a market for this, and I don't want to be guilty of conflating stuff, because we got to be concerned about that first fair use factor, the purpose and character of the use, and then it's a different factor, the effect on the market. So we got the commerciality in the first factor, and then the effect on the market in the fourth factor, and those are easy to confuse here. It's as if Goldiblox implicitly admitted that there is a market place for this, the commerciality of it, because they, rolled over when it got out that this was in Adam Yauch's will. So we recognize that there is a market for use of this music in a commercial setting, which would eviscerate any notion that this was pure commentary. This was for the purpose of selling products. Now I'll chill out and we can move on.
I see what you're saying. Yes, it would have been a close call in court probably, but it almost seems as though they architected the unaltered commercial with a fair use argument in mind, but they, just never got that far down the road with it. And probably you're right, Evan, that they did not want the PR backlash of going against Adam Yauch's will.
And that actually reminded me of what I was saying, was that the Beastie Boys refused to license their music. So fair use was the only option they had, that they wanted to use this particular song and make a commentary on it for whatever reason, to sell their product. That was their only option. There was no going to the Beastie Boys and asking them. And so that was kind of what I was saying, is there was no market for them to interrupt, because the Beastie Boys weren't licensing the music, so the market didn't exist.
Yeah.
Well, wait. No, the market didn't exist. We just met, Sean, so I'm not trying to be me. The market didn't exist because the Beastie Boys said it doesn't exist. That's different than the market existing in reality, because the market certainly does exist for the use of commercial music for the use of popular music in commercials.
Sure. There are probably people who are dying to license Beastie Boys music for commercials, but they're shut down when they ask.
Right on.
All right, let's talk about Hotfile. Speaking of getting shut down, because they were about to go to trial with the MPAA. They got a great motion in limine that Evan alluded to earlier in the show, granted in their favor, where the judge precluded the MPAA from calling them the founders pirates or thieves at trial. So they were teed up and ready to go in, and then settled big, an $80 million settlement with the MPAA. Evan, what happened here?
Well, they settled the case. I think that's the kind of the long and short of it on the eve of trial. I think that's what you said, right?
Yes.
what I think is interesting here is the news about the motion in limine that I mentioned just briefly in passing, and the news about this came out before the news of the settlement did, because those things happened, like a day or so apart from one another. And this is just a really funny little thing. It's actually a little ancillary thing. Before any trial, you see this a lot, especially in federal court. The court will issue these omnibus orders. Omnibus, of course, for the folks of us who haven't studied Latin, means dealing with everything under the sun. And so in that one order, the court will deal with a lot of different issues. And one of the things is that Hotfile had filed this motion in limine, which is a motion that you file with a court to say, judge, enter an order now before trial starts that says that the other side can't introduce certain evidence or has to conduct itself in a certain way during trial. And this motion in limine dealt with the use of piracy and the word, calling the defendants thieves. Yes. So how interesting. This is a perennial topic for us here. Is it right to call it, is copyright infringement really in the nature of theft? My feeling is it's more in the nature of trespass. But so what an interesting semantic argument here to make. And interestingly, the court granted that motion in limine, saying that they couldn't refer to the alleged conduct on Hotfile's part as piracy or thievery or what have you. Just kind of an interesting, I don't know what to make of it other than, kind of the fact that the court came out that way. But it does. There is a little bit of ridiculousness to it, perhaps, because piracy is in the common nomenclature when we talk about these things, whether it's right or wrong. They're certainly not like Captain Jack Sparrow pirates and what have you. But the word piracy goes back, in Supreme Court decisions well into the early 20th century. I think. They use the term in the Bobbs Merrill case. One of that first sale doctrine cases, I think from 1908. I think the word piracy is in there, and it probably goes back even earlier. It seems like it would. So it's kind of funny that here we are in late 2013, and courts are struggling with whether or not it's appropriate to say that. Just it's more of a cultural, social commentary than anything.
Yeah, I'm speculating that the MPAA must have had some pretty damning evidence against Hotfile for them to take things all the way up to trial and then decide to settle for $80 million, which is pretty considerable. Have you been following this at all, IS?
No, because Hotfile, this kind of case is similar to like the Mega Upload and these kinds of things. So it wasn't actually hitting the news as hard as other things at the time. But I was looking at it on my own. It's these sites sometimes reward people for having popular downloads and things, which sometimes people think that's what's the word? Is it enticement of actually doing for infringement?
Inducement.
Thank you. Enticement. That's a totally different word, but it should be a legal word. Sorry about that. And so it seemed like it was something that was inevitable. These sites they exist this way, and that's why a lot of these modern sites, they claim, look, we have no idea what our users are putting on. We can't look at this material, so what they put on is on them. We're not making them do anything. And I think that's been a shift. But Hotfile's been around for such a long time that this seemed like it's kind of the old guard all being killed off, and there will be a new one to take over.
All right. Yes, ISO Hunt is another one that got knocked down in settlement earlier on. Sean, do you think this is a trend that we're seeing?
I don't know. I mean, I can actually give you a little context for this Hotfile. So my understanding with Hotfile was that they had already, there were actually a lot of legal issues regarding infringement that were already found. So that when going into this trial was less about determining liability and more about determining what the knowledge of the people that ran Hotfile. And so because that was the key, the key question that they were asking at trial, that's where this motion in limine came from in the first place. The pirates and thieves, the reason the judge would not allow the MPAA to call them that is because that's what the trial was to find out. Were they pirates? Were they thieves? Were they somehow culpable for inducement? But the actual liability issues were actually solved. So I wasn't actually surprised to see this order come out and then the next day the settlement. If the order had gone the other way, you might have seen a $160 million settlement the next day rather than an $80 million. So right. In these particular cases, I mean, I think it's kind of a lesson that you can have these file locker services, but the second you start trying to induce people to use them, at this point, it is just clear knowledge that people are going to upload things that they're not supposed to, that it's going to be copyright infringement. And if you're going to be monetizing it or doing it in such a way to kind of cross over that line, you're going to end up like Hotfile or Mega Upload or any of these other services that are happening. So it's interesting because these services are really useful, but the ability to monetize them, especially by paying the people who drive more eyeballs to the site, is really going to be curtailed, because there's not a lot you can do without crossing over that line and getting to some sort of secondary liability.
Yep, excellent points. All right, well, we've talked about a lot of really interesting stuff on the show this far, and we are winding toward the end of the show, but we can't do that without also touching on some important legislation that passed the House this week. The Innovation Act, guys, passed the House by a resounding margin, 325 to 91 on Thursday, and is now headed for the Senate and then the White House, both of which it is expected to pass. So we are getting some patent reform. This is a good thing, right, Evan?
Sure. Yeah. I mean, this certainly seems to deal with the bottom feeders, and I'm just repeating what I've read about it. When it comes to patent law and the kind of way that it can be effectively reformed, I look to smarter people and what they say about it. So that's why I read this article by Timothy Lee at the Washington Post. Which is a great article that really spells it out here. So it seems like one of the big things that it would do here is protect individual users. You've got some of these trolls that sue the coffee shops and the hotels for example, patents pertaining to Wi-Fi, providing a wireless network. And there really is nothing that would stop, on that same logic, stopping these trolls from suing ordinary folks like you and me who have wireless routers in our homes. So part of it does, in a sort of clever way here, would stay that kind of litigation in the event that the manufacturer or the distributors could be parties to that litigation. So a couple of other good things here. So certainly a step in the right direction. When it comes to this idea of patent trolls, making it more equitable. Another big one is the fee shifting provision that would make it more expensive to lose a case. Also making it putting more of an onus on the plaintiff to prove, muster the facts earlier in the case, and also at the same time staying discovery until some of the more weightier issues or meritorious issues are done up front. So it seems like a sensible way. I'm sure that there are ways of criticizing it and saying it doesn't go far enough. But, from what I see, this looks like a positive development if we start from the premise that patent trolls are bad.
Yeah, and I think, we can start from that premise. I'm all for that premise. The article that you referenced from Timothy B. Lee in the Washington Post had a good response to the issue of whether the bill would unduly burden legitimate patent plaintiffs. And Timothy B. Lee says that, goes through the points of the bill and doesn't really think that that's an issue. If you've got a real strong, valuable patent, you're not in this for the litigation cost holdup. You want to be paid by the infringer, and nothing in this bill is going to stop you. So that's a good assurance for those who are worried that patent law is being eviscerated by this. That's not what's going on here. Sean, have you been following this?
Yeah, and this is actually something, Timothy Lee, actually, before he came to the Washington Post, actually wrote an academic article about kind of the patent troll problem. And it's interesting because the point that he actually makes in this article, and it's really good to see, is, this is a back-end fix. This is a fix for the back end, the results of a front-end problem, and that is too many patents with unclear boundaries being issued in the first place. And these are generally your software patents, your business method patents, things that didn't exist 10 to 15 years ago until a federal circuit case called State Street. And so, this bill does fix the problem of what happens when you have a low value patent and it's just used to extract ransom from especially, like you said, a hair shop with a Wi-Fi network. But it still doesn't fix the biggest problem, which is the quality of patents that are, or at least that were issued over a 10 to 15 year period. I actually have a lot of friends that work at the PTO, and it seems like the newer patents, especially in light of the recent Section 101 cases, which I'm not going to go into, there's a little bit more stringent standards. So you're seeing a little bit more definiteness in the claims, but you still have this huge universe of patents out there that are very low value, and it costs a lot of money just to figure out, does this thing even apply to me? And so this kind of fixes that back end problem, but the front end problem needs to be fixed too. I mean, patents need to be issued for things that are really, truly innovative and good inventions. They need to not be implemented for a small change in a program's algorithm. So.
All right. Ayaz, are you excited that we have a move toward patent reform that looks like it will become law?
If it works, yeah. I mean, the idea was that if you want to have products that can be on shelves, right? You want this. You basically, when you're a consumer, all you want is your gadgets. And if it's getting stopped because some non-practicing entity's like, you know what, that's going to cause an issue. That seems to annoy a lot of people. But the thing is, as an end consumer, you don't even see those products because they're banned, and you have all these stories in the background. So if it actually makes a difference, and these trolls, I should say, really, because there's a lot of companies that do research and development. Like IBM is a good example of this. They don't exactly make products anymore. I mean, I know they do certain things, but they have tons of patents. They make billions of dollars on their patents every year. It's the trolls that are causing problems, not necessarily people who hold patents.
Yep, you're absolutely right about that. Let's go ahead and make the Innovation Act our second MCLE passphrase for this episode of This Week in Law. We put these in so that you can demonstrate from those accrediting boards for continuing legal or other education credit that you've actually listened to the show. So we just sort of randomly drop these phrases in. Each show has a couple of them, and you can demonstrate. Indeed, I tuned in and watched or listened to episode 238 of This Week in Law. Also, if you're curious about the various stories we've been discussing on the show, want to go back and refer to something that you remember came up, you can go to our Delicious links, delicious.com/thisweekinlaw/238. We'll have everything that we discussed or planned to discuss today and didn't quite get around to. And I think that's the situation we find ourselves in because we're getting down toward when we need to wrap up the show. So let's give you our tip and resource of the week. Our tip of the week comes to us via a viewer who read something by Oren Kerr at the Volokh Conspiracy, who pointed out that more and more judges and lawyers are using URL shortening services like GOO-GL, Google's, or the various other ones that are around out there. And I guess the tip that they wanted us to convey is rather than put in some god-awful 3-line single-space long link into a brief or a judicial opinion, you should go ahead and use these URL shorteners. That's what Oren Kerr is suggesting when writing an important piece of legal work. And while I agree with that, I do caution folks when doing that is we talked a while ago about the fact that so many of the links in Supreme Court opinions are dead links now because there is no obligation on the part of anybody putting something on the internet to keep it there. So if you're going to go ahead and use URL shorteners, do look into perma.cc, which is something that is created just to address this problem. It gives you both a short link and something that will make the link preserved over time. It may be a little bit more labor intensive than what people are interested in doing when they're quickly putting together a document or an opinion, but it matters over time whether these things can have an accurate reference to their authority. So pay attention to how you're linking to things in briefs. And our resources of the week this week will be twofold. Number one, I wanted to give folks a nice, if you haven't gotten enough information about the Innovation Act and what it means, there's a really nice explainer from Tim Lee at the Washington Post, and it's a blog called The Switch. Everything you need to know about the Innovation Act and all the various pros and cons, what's in the bill. Again, that's in our delicious links at delicious.com/thisweekinlaw/238. The other resource I wanted to point you toward, I mentioned it when I introduced Ayaz on the show, is his show Know How, which gives you so many bits of practical advice on putting things together, setting up devices. I recently checked out, I forget, it was like number 28 of your show, I asked something like that, on setting up an Android phone for a child's use. Really valuable one that's out there. I'd encourage you were skewing that one for a 2-year-old.
Yes.
I'd encourage you to do a follow-up show for, a tween or early teenager, because you've got different considerations in mind there, which definitely involve a bit of legal gloss when you think about how much you're going to permit your child to interact with people online. There's cyberbullying considerations that come into play. And there's also, how much are you going to monitor your child? How much personal freedom is a child entitled to? Definitely love Know How and all the things you guys do over there, Ayaz.
Thank you. Now, that's a great idea for an episode. So yeah, it's at twit.tv/KH. That's Know How. And that episode back then, I made a phone for my son because he constantly was trying to take my cell phone. And I'm like, well, this is connected to my Google Wallet. It's connected to everything. He can buy stuff. Maybe he shouldn't be doing in-app purchases, because there was a lot of those stories coming up too. So I gave him a little Boost mobile phone, and I rigged it up with special icons so he can have his Cars movie and things like that. But to have a phone for your tween, now that's intriguing. I want to find out a way that you can absolutely spy on everything that they're doing, because then they become paranoid and they might not use the device as much, but at least they would believe that. Maybe it'll be on the router side, how they can actually into this. So this is a really interesting idea, and I'm going to have to write that down, because I'm going to steal that or say thank you,
You and I
Denise.
should chat, because I just set up a phone for my 10-year-old and went through, all of the various questions.
Sounds
and
great.
It's stunning to me that there isn't more attention given to this on the vendor's side.
Yeah, they just want to give them the real
just
phone, and they want the real credit cards. And like, of course not. We're not going to do that.
No, they did. They really don't pay attention to it at all. I did learn that AT&T offers a phone location service, something like Find Your iPhone
for kids.
It's Find Your Kid, yep.
Yeah, it's
called
more
like the
about
Fill Up or
Find Your
something.
Kid. Yeah, it's Family Map, I think it's called.
Okay.
And the funny thing about that, and you're talking about doing it in a stealthy way, IS, is they actually do send a periodic text to the child's phone that lets them know they're being monitored. They say, their lawyers have decided that they have to do that they can't let parents clandestinely follow their child's location, which is sort of funny because if you're, whether you're using an iPhone or an Android, there are other location services you can use that don't text your child that the phone is also being tracked. So
that totally sounds like a California thing.
Yeah, and as we all know, kids always read the terms of service in every disclosure they're given.
No, but I know that mine, for example, will pay attention to a text that he gets on his phone, and that's how they're being delivered. So interesting stuff there. We can, talk about that at a later date. But thanks so much.
Thank you so much. This is great.
Yeah. All right. And Sean, it's been really wonderful chatting with you. We look forward to your, we speculate, many appearances in action films with your great name, Sean Flame.
Right.
looking for you either streaking down the road in a self-driven car, an auto-driven car with Google Glass strapped to your face and a drone buzzing by, chasing you up the highway.
Actually, I kind of think that might be the first use of these drones. I mean, why bother with the high-speed chases? Just send the drone after them. So,
great idea.
Absolutely, yeah. Or at least they can track the speed and grab a license plate. It's like a traffic cam gone up in the air. So, Sean, is there anything coming up that you want to plug or let us know about in your part of the world?
No, not so far. I mean, I'm still. I told you I was working at the Social Security Administration, but I'm also still operating this space. I just don't have as much time. So, as I said, I have something coming out at some point within the next 6 months or so about fair use. So, if you see my name connected with it, then but I can't really give you any more information than that.
All right. Well, we've been really thrilled to get some of your time on the show today. Thanks so much for joining us. Evan, great chatting with you as always. I'd love to see that you're sporting your holiday facial look.
That's right. Yeah, I got started on this at Thanksgiving. As viewers know, my wife lets me do this once a year. Actually, grow a beard. So it's that time of year. So
most wonderful time of the year.
Right. It's like the Ayaz time of year.
With your facial hair and my neck hair, which everyone has been, not actual neck hair, on audio, but I'm wearing this rather thick scarf/collar that, yes, is completely synthetic. Only polyesters bit the dust for this thing, but it's very warm and cozy and is my version of having festive fuzz around my face for the holiday.
Right. It looks like sometimes a breeze catches you. And so I think that's why people were asking, is it alive? So,
yes, every now and then it starts
right.
undulating around my neck. No, it's just laying there, fortunately. I don't know. If it starts undulating, let me know.
Good. Well, I'm glad you can stay warm in the chilling California winters out there. So.
I know. See, here in Southern California, when it dips below 60, we all start to shiver and cringe. Right. And it's been under 20 up in Aya's neck of the woods. So, and I'm sure probably in your neck of the woods too, Evan.
Yeah, I mean it's starting to be winter. There hasn't been like a big huge snowstorm yet, but it's starting to be like December outside here in Chicago. So it's beginning to look a lot like Christmas. But anyway, it's been a lot of fun today. I'm glad to be back. I missed not doing the show last week after Thanksgiving, but this has been great. Sean, really nice talking to you. Really have enjoyed meeting you and talking about all the stuff that we've talked about. So good luck. Stay in touch with all that
yes.
Yes. And Ayaz, always good to talk to you.
It was a pleasure talking to you, Evan. And Sean, it was brilliant work.
All right. Thanks so much.
And Denise,
guys.
Obviously. Duh.
Thank you. And thank you all for listening. If you've been joining us live, you've been doing so at 11 o'clock Pacific time, 1800 UTC when we record the show. But you don't always have to tune in at twit.tv to watch us live. You can go to twit.tv/twill, and there you will find our archive of shows. Or if you're a YouTube person, you can go to youtube.com/thisweekinlaw. We're on iTunes. We're on Roku. Various other sundry places where you can pick up netcast entertainment at your heart's content. We'll be there along with all the other Twitch shows, and we're happy that you join us in any way that you would like. If you like participating in the show, jump into our chat when we're recording live. That's at irc.twit.tv. And you can participate when we're not recording live, too, by getting in touch with us. Evan is Evan at twit.tv. I'm Denise at twit.tv. And we've got presences on Twitter. Obviously, he's Internet Cases there. I'm D. Howell there. And on Facebook and Google+. Each of those venues has pages for the show where you can go and give us feedback on what you listened to, what you'd like to listen to, what you'd like us to cover. Guest suggestions are always very, very welcome. So go ahead and give us what you got. We're excited to hear from you in any forum that you would like. And we're thrilled that you joined us, and we're looking forward to a very pleasant holiday season as we wrap up the year here at This Week in Law. Tune in next week. We will be here. See you then.